So now let's talk about the Google Books project, the Breitbart case, and the European Copyright Directive. So the Google Books project began as an effort by Google to scan the books in various university libraries, such as the University of Michigan and Princeton and Harvard libraries. And as I mentioned earlier, under U.S. copyright law, anything that is published before 1923 is in the public domain. So there's certainly a large class of books that there would not be a copyright issue concerning. But Google also scanned books that would currently be subject to copyright. And what Google said it was doing was that the books that were out of copyright, it was scanning and making available in full text, and books that were still in copyright, Google was making searchable but was only providing snippets, that is small portions or relatively small portions depending on how you look at it, of those books available to the person doing the search, so that if you wanted to actually read the whole book, you would have to really go buy the book. But the argument by both groups of authors and groups of publishers was that Google was infringing copyright, and that even providing the search function and the snippets to these books was hurting the publisher's market for the books. So if you want to try it right now, just kind of pause the video and go over to Google Books. You can go to Google and do more on the Google search and look for books, and just type in the title of a book, and you'll see whatever it is you type and some other related things come up, and you'll click on it and you can see the snippets that are made available to you. I've found this to be a really useful source in my research. It kind of gives some initial leads for things. It occasionally does allow me to find a source that I really don't need anything more than what if I'm looking for a specific historical or data-based fact, I might find it there. Occasionally I've used it where I found a snippet of something and I've wanted the whole book, and I've either bought it or I've had the library buy it. It's also really interesting for older books. I'm going to show you on the screen here. I was doing this. It's kind of fun to try and do this and put your own name in and see what comes up. And when I put my last name in, there's a Holger Opterbeck who's actually invented some of the key technology of the internet, who's a distant relation of mine that I've never met. So a lot of his stuff comes up. Some of my stuff comes up, or things that quote me in different books. A little bit of that comes up. And I found this old book with this distant ancestor of mine from the 19th century who fought in the Franco-Prussian Wars, and apparently was a bit of a troublemaker and was injured in the war, but went on to sort of achieve fame by having his arm shot off and becoming the mayor of his town. So it's just fun to find, I think, to find things like this. And so there's a sense in which this project is really cool. This is Google really digitizing the world's knowledge and trying to make it available. But pretty quickly, it ran into this litigation by groups of authors and groups of publishers who still had works in copyright. The initial round of this litigation led to the possibility of a settlement. So there was class action litigation. It led to a class settlement, and the class settlement would have allowed Google to continue this process concerning works that were still in copyright, and would have set up a system through which Google would have provided some opportunity for remuneration to the individual authors and to the publishers. So it really was going to let Google kind of, undertake this and kind of be this big global digital library. But the settlement ran into trouble in the district court, and class action settlements have to be approved by the court, and the court rejected the settlement. And if you take a copyright law class, if you take my copyright law class, I spend a lot more time talking about this, or in the new media law class, I'll spend a little bit more time talking about everything that went into the settlement and why it failed and its context in relation to the developing ebook market at the time. Again, look at the date of this, 2012 or so, when this is happening. So the settlement fails, the litigation goes forward. There's an issue about class certification, whether there's a properly maintainable class. That issue gets appealed. While that issue is under appeal, there's a group of author plaintiffs and there's a group of publisher plaintiffs. The publisher plaintiffs reach a settlement with Google. That settlement is mostly confidential. So this is another interesting dynamic of this that we can talk a little bit about more when we meet together. But Google did reach a deal with the publishers, and part of that deal involves the way in which when you pull up a book that's under copyright, there's a button in which you can click to then buy the book. That seems to be part of this settlement with the publishers that really allows Google to do this. But the claims by the author groups, still go forward. The issue of class certification is on appeal. But meanwhile, on the issue of the author claims, the trial court granted Google summary judgment on the question of fair use. And then that fair use question was appealed to the Second Circuit. And that's the opinion I asked you to look at, in which the Second Circuit affirms the district court and says that, yes, indeed, what Google did here was fair use. So as you read this case, notice how the court goes through the 4 fair use factors, how the court notes that some of the factors are potentially going to be more important than others. The court finds that there's some interesting discussion about what transformative means here in relation to the purpose and character of the use factor. And the court says that the way Google has done this is transformative. Now we'll talk about this a bit in class, but think about it. Was it really transformative, or did Google simply use a technological means of search that the publishers themselves could otherwise have used? This court found it transformative. The nature of the work and the amount and substantiality used, the court suggests are not as important factors in this context, although they play some role. The effect on the market, the court said these snippets aren't really going to substantially negatively affect the market for the author's work. The court said, maybe there's the occasional, the sometimes loss of sales in the kind of circumstance like I described to you, factual research, but the court thought that isn't as major an impact on the underlying copyright interest, in that, where you get a snippet of, say, a novel or a more creative kind of work that you think you'd like to read the whole thing, you'd have to buy the whole thing. So in some respects, it might even have a positive effect on the market. So this was a really significant opinion. It really kind of cemented Google's ability to function as, again, a kind of determiner of what is happening on the content layer. Many in the copyleft community, if you want to call it that, thought this was a great decision. It's sort of vindicates the fair use interest. But in the author community, there was a lot of concern, and even in the publishing community, though they had reached this settlement with Google, I want you to notice a pattern between YouTube, with search, as next week when we talk about antitrust, here in copyright. Google is this enormous player, and there are a number of others like Amazon and Microsoft that are these big players that are really driving a lot of the law and policy. And what do we think about that in terms of the notion that the internet is supposed to be this space of kind of open collaborative governance? So now let's look briefly at the Goldman v. Breitbart case. So this is a really interesting recent case, and as I mentioned, the issue arises because there's a photographer who takes a picture of Tom Brady walking down a street in the Hamptons with Danny Ainge, and up here in the corner is that picture. And the photographer posted it to Snapchat. It was then taken off of Snapchat by some bloggers and other sports type people and individuals who put it on Twitter. And then those third-party Twitter feeds were embedded in the sites of various news organizations and other blogs who were speculating about, why Tom Brady is talking to Danny Ainge, about basketball lineups and other things like that. Just so you have a sense, if you want to link to an image, the case law seems to have been pretty clear, to the extent there was case law, and there wasn't a lot of it, that linking is not an infringement of copyright because, and as I mentioned in class last week, there was concern about this in the internet law community in the very early days of the internet because, linking is how the web works. And if a link is an infringement of copyright, then you'd have to get a license for every link, and how would that work? So the consensus kind of developed that if you put something online on the internet without any kind of technological or other restriction, and somebody links to it, that they at least have an implied license to do that. And so if you kind of look at the way the code would look, this would be the basic code for a hypertext link to an image. Here we're actually talking about embedding the image. So actually taking the image and not just saying here's a link to the image, but simply posting the image to the site directly without stating that there's a link. So it's an embedded link. And you could look at this case as a sort of distinction between perhaps embedding and linking. Now, does that all matter? I'm not sure. What the prior law had said is that it kind of developed what came to be called the server test. And the idea was that if the image doesn't reside on the defendant's server, so you've not made an actual copy of the image and put that copy on your own server, but you've only linked to it, and the link is served up from another server, then the defendant who has the link is not infringing copyright. And that ought to apply, whether it's a hypertext link or an embedded link. But the district court judge in this case, said, well, I actually don't think the server test is the right application of the display right under copyright. Effectively, she said, I think the server test wasn't really correct when it was first developed in Perfect 10, and/or that the way the internet has developed has shown that isn't really the right test, and that this is a different kind of case because it's an embedded link. As I mentioned in class last week, and we can again talk about this more in class this week, this case is really something that internet law scholars are watching because it has the potential to upset some things that we've really taken for granted in terms of how the internet works and what is permissible with respect to copyright and links and what is not. My guess is if this case proceeds and if this issue is heard on appeal, my guess is that the Second Circuit would kind of reaffirm the server test or something like it. I think it would be very, very difficult as a policy matter to say that this kind of link is an infringement of copyright. Although I could be wrong, and it might be that because the original photo was posted on Snapchat and a different kind of site, and not exactly the same as an open architecture internet site, and then was taken by others onto Twitter, maybe that makes it different. I don't know, but this is a very interesting issue in terms of how we think copyright works on the internet. All right, last issue I want to talk about is the proposed EU copyright directive. First of all, what is an EU directive? So the way lawmaking works, generally speaking, in the EU is that the European Commission, which is a body comprised of representatives of the EU member states, will come up with a proposal for a basic kind of structure of law. that proposal, under some circumstances, is then given to the European Parliament for their input and approval. And if the directive then becomes law, then each of the individual member states has to conform their national law to the directive. So the directive isn't, a directive of this sort isn't itself the law that directly applies in each national member state, but the national member states have to adopt law that conforms with the directive. There are other kinds of European law that, like a European regulation, like the data protection regulation, will apply directly in each member state as is, but the directive then has to be implemented. So in any event, it's European law. The provisions you want to look at and think about that were controversial were Article 11, which the opponents of the directive called a link tax. And if you notice when you read it, it creates a new form of right for press publications, and it would give these press publications a 20-year term of protection. Now, what is this all about? Why would you even have to do this? Aren't these things already copyrightable? It may be that since some of these things are news reporting, that they either wouldn't be copyrightable or would have thin copyright, or under the way copyright law tends to look at linking, it would be permissible fair use to link to them. Well, who links to things like this? On my own blog, I might link to a news site, something like that. That's not really what this was all about. What it was about was big aggregators like Google. So here is a screen from the Google News site, and there are other sites like this that aggregate news content from other providers. So what this is trying to do is get these big aggregators to have to get a license to link this kind of content. Again, kind of different than the way we think of hyperlinking practice, but notice that Google is definitely still an entity that's at the center of it. The other article that was really controversial was Article 13, which critics call the upload filter. So if you read this, it will in some ways sound similar to the DMCA, and it will in some ways sound similar to the YouTube case. And as it relates to the kind of things that were at issue in the YouTube case, remember that I said part of the big fight is who has to bear the cost of adapting and using technology that is from the outset going to screen out infringing content. And so you can look at Article 13 as an effort to require the platform to develop that technology. And yes, that would mean Google, and that would mean other sites like Google. And so you can kind of think about whether that would be a useful kind of policy or not, and who should really bear that responsibility for internet governance. As it stands right now, the copyright directive, somewhat surprisingly, was rejected by the European Parliament, primarily because of a big public relations campaign by copyleft and open internet groups. So we'll see whether it gets revised and whether there's something else that gets through the European Parliament or not. But this is a very live issue in terms of internet governance. So this is the end of the videos for this week, and I will see you in class on Thursday.